Good morning, Counsel.
Good morning. May it please the Court. My name is Richard Farrell. I represent Ernest Solomon, the surety in this matter. This case involves a relatively straightforward interpretation of the Massachusetts bail statutes, albeit on a 12 pages worth of convoluted factual background. The case here is controlled by Massachusetts Chapter 276, Section 70, which provides that a surety that posts bail can get their bail back in conditions where, by situation out of their control, because of action of the federal government, action of another state, acts of God, or sentence.
What is the proof that an act of the United States government has kept him from appearing in court?
Well, there's several different things. There were findings by the court below that there was, in fact, a detention. I believe that...
there was a detainer.
Yeah, I believe on page 12 of the court's order, it finds that there was a detainer. There's also the notice to appear that was signed by Bautista, and there's also obviously the failure of Bautista to appear.
So all we know is there's a notice of detention. Where is he? I mean, is he been deported? Do we know that? We don't have any evidence of where he's being held or anything.
The court's finding was that he had been taken by federal authorities and removed.
Is that based on evidence or just a representation of counsel, or?
It's based on the representations of counsel below, but the findings are explicitly made by the court in its order.
The judge knew about the ICE detainer, right? The bail judge knew about the ICE detainer?
It's not clear from the order whether Judge Lemire, the judge that set the bail, knew about the ICE detainer or not. That part's not clear because he's not the judge that was involved in this.
And what about the agreement with ICE? Did he know about? Do you know anything about that?
The judge that set the bail?
Bail judge, yeah.
It's not clear from the record whether the bail judge was aware of that.
I'm inferring that in order to get this defendant into the custody of ICE, he had to have gotten released on bail. Is that fair to say? In other words, would they have taken him right out of the jail?
What my understanding of what happens and what appears in the record is that upon the posting of bail, the INS detainer then kicks in.
Right.
So when the bail is posted...
he had to be released on bail in order for that detainer to kick in, correct?
Correct. So long as he was awaiting trial, the detainer would not have gone in.
So when you have the posting of bail on January 30th and he goes into custody of the federal government the next day or something, isn't that right? About February 2nd or 3rd?
Well, it's my understanding, and it appears that it's instantaneous.
Okay,
as soon as the bail is posted, he never leaves.
And you're saying that even though one could infer that that was all by arrangement, that this is without fault on Mr. Solomon's part?
It's my position that the statute does not provide for fault. It does not...
Doesn't it talk about by act of the United States government without fault of the... Isn't that part of the statute?
It does. It's my position that the without fault is modified and defined by, in fact, the four preceding factors: the acts of federal government, the acts of another state.
But you wouldn't disagree that one could read those as independent conditions.
I believe if you read them as independent conditions, what happens is the scheme of the bail statutes, in essence, is undone. Because if you take out the defining and limiting clause, those four items, what happens is the sentence would read, if bail are unable without their fault to surrender their principal. Now, if you read that sentence that way, what happens is let's say the person doesn't go to court because they're in the hospital. They don't go to court because they're in another state. They don't go to court because they don't want to come and get out of bed. That's not the fault of the surety. So if you take out those four defining characteristics, the fault of the federal government, sentence, act of another state, act of God, now the whole purpose of the bail statute becomes sort of undone, because it's not the fault of the surety if the person who's bailed out just elects not to go to court.
That's what surety is for. To make sure that the defendant does appear, that he does get out of bed and go to court.
Certainly, and that's why Section 70, I believe the legislature wrote it the way it did.
But it doesn't, under your reading, it seems to me that the without their fault is superfluous, because if any of those conditions exist that start the sentence, you say that by definition is without their fault, so why do you need to say it's without their fault? If those exist, surety, you're fine. You get your money back.
I think that those four conditions are what defines without fault. You are certainly correct. I believe that the without their fault might be superfluous to a point, but I think that is defined by the four conditions precedent. The times when it is not their fault are those four times. And this is one of those four times when the federal government has acted, has taken Mr. Bautista out of the control of the Commonwealth.
And you'd say that, and I'm not saying that this is necessarily on this record, but hypothetically, if the surety did all the arranging to make sure that that happened, it would still be fine. Surety does everything, pays the bail, has prearranged with ICE that they're going to come the minute that bail is paid. They're going to take this person, avoid the whole state prosecution of many trafficking offenses, and that's fine, and the bail comes back to the surety.
Your Honor, I don't believe that's the record here, but to address your hypothetical, I think that if the legislature intended to change that to add some sort of provision that the surety not arrange this, then it could rephrase these statutory provisions such that, well, for example, the judge's order cites out of jurisdiction cases, and many of those cases involve specific wording to the effect that the incapacity or unavailability of the person bailed is due to the connivance or the cooperation of the surety. The Massachusetts statute doesn't say that. In fact, in other places in the bail statute, they do refer to the connivance of the bail. And so in Section 70 itself, that's not referred to.
Why was the bail posted 7 months after the detainer was lodged?
I don't believe it's clear from the record exactly why it was
It doesn't
posted
make sense. I mean, why would you post bail on a deportation detainer?
Get the deportation to happen.
In fairness to the convoluted history, I think part of this has to do with when the $5,000 bail was set. Because that bail was set earlier in the month of January. It was finally set at $5,000 on two cases.
But it was posted on January 30th of 2009. The detainer was lodged on June 19th of 2008, 7.5 months earlier.
Certainly it was, and I believe
$20,000 at that point, right? Wasn't the bail?
the bail was higher at that point. It was reduced, I believe, on January 12th of 2009.
Okay, but the bail was posted 7.5 months after the detainer was lodged. What was the purpose of that?
Well, the bail was only posted 3 weeks after it was reduced to a reachable amount, I would submit. And
Was there any chance he could have gotten out?
Well, in this case, Attorney Solomon represented to the court that he believed there was a chance that he might be released, that the detainer wouldn't have lodged. It's not clear from the record what the basis of that was, but it was represented to the court that Attorney Solomon posted this bail without being sure that the INS detainer would have the effect it did of taking Bautista out of the state immediately and into federal custody.
So, I mean, the bottom line, to be blunt, is you claim there is this huge loophole in the statute which says that if a surety, and again, I'm not not speaking of your client, but if a surety were in complicity with a defendant to get him out of the country because he knows that ICE doesn't care about what is happening in the state proceeding and will proceed to remove somebody from the country even if they have pending charges, that the surety can do that and get his money back. That basically is the loophole you're saying the statute leaves us with.
It does, the structure of the statute does appear to leave that hole. I think in fairness to the legislature and interest of candor to the court, obviously, these statutes are old, and they weren't necessarily designed with, sort of modern ICE practices in mind. So this may not have been foreseen by the legislature, and that's why my position is that the legislature has to be the one to come in and repair this statute, and repair, as you've termed it, the loophole here, where if the federal government comes in, it becomes a situation where the surety can get their money back. If there are no further questions,
Thank you, counsel.
Good morning. May it please the Court. Jane Sullivan for the Commonwealth in this case. It's the Commonwealth's position that the motion judge in this case correctly forfeited the defendant's bail and then properly refused to return the bail to the surety. Just by way of background, bail was posted at the courthouse. When the bail was reduced, the Superior Court judge reduced the bail from $10,000 on each case to $5,000 on each case for a total of $10,000. There was a specific order in the docket that the bail be posted, if it was to be posted, at the courthouse. Instead, and then on, I believe it was January 28th of 2009, the surety came into the House of Correction at 6 o'clock at night and provided a check for $10,000, knowing, as the motion judge found that the surety did so, knowing that the defendant earlier, back in June of 2008, before he had been arraigned on any of these Superior Court indictments, that ICE had lodged a detainer against him, and that the defendant had waived any and all rights to challenge deportation. He essentially...
So that the surety, Mr. Solomon, knew that he had agreed to voluntarily depart in lieu of deportation proceedings. You said he knew that.
Yes, yes. What the motion judge found was that the surety, when he tendered the bail and entered into the recognizance contract, that he knew about the detainer, about the defendants voluntarily submitting to deportation. Yes, that he knew that.
So is it your view that that's sufficient to find essentially fault? That knowing that there is a detainer and that the individual has entered an agreement to voluntarily depart and posting bail in those circumstances is fault?
Yes, posting this bail in the circumstance in which it was 6 o'clock at night. The surety at that moment knew that
what does 6 o'clock at night have to do with it?
Well, the surety at that point knew that he had handed over a $10,000 check, and the defendant was not walking out the door with him. Now, the surety did not come into court, and the surety did not go to the court. As part of the recognizance, the defendant, guarantees that he would not depart without leave. And the surety signs, and he understands, and he guarantees that the defendant will abide by these terms, or he will forfeit the bail. And that is January 28th of 2009.
I'm sorry, but mechanically, I mean, bail is posted. I'm sorry, I'm confused about why nighttime has anything to do with this. Bail is posted, and he's then released to the ICD detained and taken away.
My point is that bail is posted, and what a surety would ordinarily expect is that his bailee or whomever walks out the court, walks out of the jailhouse with him. Instead, here, this defendant remained there, and I believe, based on the representations later from the surety and counsel, that he was immediately swept up by ICE. But he never left the courthouse, is what was represented to the judge.
Would you say then that surety should never consider bailing people who they have a sense will be deported?
Well, if they do, they assume the risk that they lose their investment.
If the person is deported, then they're going to default, and they lose.
The judge basically said clear that the defendant and the surety basically knowingly acted together to do whatever acts were necessary
didn't make
to
that
get him
finding.
deported and evade
And
prosecution.
the ultimate finding is he assumed the risk. So, I mean, I guess I'm troubled by that because, as Justice Island just said, if you could posit a factual situation where let's just say that the surety doesn't know about the detainer, doesn't know about any of that, posts the bail, is part of a church group that the defendant had belonged to. Finally, it takes a long time to get the money together. They post the bail, and unbeknownst to the surety, ICE steps in, takes the defendant. That you say that surety should lose his bail?
Well, if it's unbeknownst to the surety here, certainly that was not the case
Well, the
here.
judge said assume the risk, so that's what I'm wondering
But he
about.
he doesn't just simply say it's just assuming the risk. I mean, I'm saying that a surety, in certain circumstances, it's incumbent upon a surety who's going to present money and put it at stake contractually to at least have some sort of investigation. There's some obligation to look at the facts and circumstances surrounding the person that you are going to offer the money on. And yes, I think there is some responsibility, so you would assume some risk. But here, the judge found more than that. They found basically a
So you have
complicity.
to look at all of it together.
You have to look at, I believe it, particularly in this particular case, you look at all of it together. And number one, it was up to the surety to prove both that an act of the government caused the defendant's failure to appear, and two, that the surety was without fault.
So
And the motion judge,
it's the surety's obligation to prove that he was without fault?
yes, I believe it is, because we're acting under Section 70, and that is based on a surety's motion for exoneration of bail.
Doesn't that invoke the very same concerns that Justice Botsford raised? Is that if the surety has to prove he's without fault, that's a burden that many people, when they're bailing immigrants, aliens, may not be able to meet? I mean, isn't the result of what you're proposing going to be that it's going to be very hard for any alien to get bail money?
No, not necessarily. All that had to be done in this case is, he could have at least alerted the court. He could have posted the bail as the judge required in the courthouse. Then the parties could have been on notice, or he could have asked, I waived deportation, but and ICE is going to take me unless someone steps in. But no one knew, and this surety waited 6 days. He did not immediately, when the defendant didn't leave with him, he did not immediately notify the court and say, I need some help here.
But what could the court have possibly done? You've got ICE has, the Supremacy Clause is going to prevent anything from the state from
We
doing
could have at least asked. We could have at least been notified. At this stage, it's only the defendant.
Could have gone back to court for an increase in bail. Has there been a change in
Or something
circumstance?
before wherever he was whisked off to, but it has to happen immediately. And in this particular case, this surety surely knew at 6:01 after he posted the bail and he wasn't coming out with the defendant, that there could be a problem.
But what's the complicity? I mean, what was this heinous act that
Well, it's
the
not-
lawyer did, that participated in?
What he did was he posted bail,
That's
$10,000.
a legal act.
That's a legal act, but in circumstances knowing that there was an ICE detainer, that the defendant had.
Well, so that's an act of stupidity.
That's a question of fact, and the motion judge found that it was more than an act of stupidity.
Why is it more than an act of stupidity?
I think if you look at the circumstances in which it is done, the defendant is facing 2 sets of trafficking and other charges.
But posting bail wouldn't change that. He was still going to get deported.
After he was tried and convicted, if he was convicted, and after he did his 5 to 17 or whatever sentence he was given after the conviction. So by posting bail when he did, after so many months after his arraignment, after he got the bail reduced, he evaded prosecution.
When was trial scheduled?
Trial hadn't been scheduled. The fact of the matter is, this only came to the court's attention when the surety came in on at some point in February 2nd or February 3rd, asking for a return of bail. The case was not on. It wasn't scheduled. The judge knew nothing about it. So it was scheduled.
I apologize for being so obtuse about this, but what did the lawyer do that obstructed court procedures?
He facilitated the defendant to go to ICE, but for the bail money, the defendant would not have been released to the ICE detainer. He would have been haved in from the Worcester County House of Correction on March 2nd when the case was scheduled for a status conference and to set a trial date. But because he posted bail when he did, and he knew that the defendant was not going to be released, despite his guarantees in the recognizance form that I will make sure that this defendant appears in court, and the defendant's guarantees that I will not depart without leave. Even that contract on its own.
Would you
gives
agree
the-
with me? Would you agree with me that the entire focus here should be on the actions of the surety, not the actions of the defendant? Question is whether the surety was without fault.
Yes, that's the whole issue, is whether
All
the
right, 'cause
surety
the judge makes all kinds of findings that the defendant's failure to appear was his own fault, that the defendant's actions clearly suggested he had an intent to evade. All it says about Solomon is Solomon knew or should have known of Bautista's voluntary surrender to ICE. On its last page, when the court makes its findings and says, for the foregoing reasons, you don't get your money back.
And on page 7, I believe, it says, of the judge's findings, it's at the addendum page 10, by June 20th to...
Right, that
you
he
know,
knew, that Solomon knew all of these things.
He knew he was in the United States illegally. He knew there was a detainer. He knew he'd waived his rights to a tribunal and expressed
But
his intent to return.
But you kept saying that the judge made a finding that he was complicit with the defendant's intention on evading, or with the... He didn't find a complicity. He didn't make a complicity finding, did he?
Well, I think he essentially does. I mean, yes, I would say...
Essentially.
Where you say knew or should have done, that could be negligence. It's not complicity.
Knew or should have known, yeah, that's what that...
It's still fault, no matter, well, I mean, however you term it, I would still suggest that it still falls under the statute as fault.
Should we require the judge to make a finding that, in fact, the bail or the surety was complicit in the defendant's intention to evade the proceedings in Massachusetts? Do we have to go that far?
Excuse me, Your Honor?
Well, you say there's got to be a finding of fault.
Well, no, the statute says that there's got to be some showing, right, that there's without fault, that he is without fault. And I suggest that the statute puts it on the surety. The surety is the one, the bail's been forfeited. The surety is the one who's coming into court asking for return of the bail. And the statute clearly, I suggest, places the burden of persuasion, proof, whatever, on the person seeking the relief from the court. And this is the surety seeking exoneration from bail.
Going to the language of the statute, the word bail is used, which I think we all agree means surety, correct? Do you agree with that?
Yes, I think I agree
Okay.
with that.
When did Mr. Solomon become a surety? When did he become a bail under the statute?
When he posted.
I would imagine when he I would imagine when it was posted,
Okay,
when he,
and
the
so-
recognizance contract, I would
Okay,
suggest.
and I guess my question is, if he did not become a bail or a surety until he posted it, at that point, what fault did he have? What control did he have after he became a bail?
Who have?
The bail, the surety.
Oh,
I mean, my question is, he didn't become a surety until he posted bail, and upon the posting of bail, then he was no longer at fault because the federal government did what the federal government chooses to do.
No, but the point is that he posted bail knowing full well that the federal government was going to come in because the defendant had already laid the groundwork for voluntarily submitting to deportation, and the detainer was there. The defendant had requested a hearing before the ICE tribunal. So in those circumstances...
So you're saying the statute should be read that the person who will be the bail before he becomes a bail, if the person before he becomes a bail is at fault, that meets the statute definition here.
No, I think all I'm saying is that the statute requires a showing of whatever, that you were without fault.
Okay, but,
and in
but,
order
but
to
I guess
meet
my
that,
point is, once he became a bail, he was without fault.
I would suggest
Because
no, he was not
What
without
could he have?
fault.
What could he have done? He had just posted
couldn't-
$10,000 bail. Now ICE has him.
He knew when he was posting the bail that ICE was
Before he
going to take
became a
him.
bail, and then he hands the
And
money
then
over.
after
And as soon as
he
he hands the money, the ball game's over. Now ICE takes control.
And then after he posted the bail, he knows that he had signed a contract guaranteeing that he would make this person available in the state trial court, and yet he does nothing. until 6 days later when he comes in and makes representations, well, he's either been deported or he's about to be deported, very vague. The motion judge doesn't find anything about being deported, and there's a footnote in his findings that says no documentation or anything was ever presented to me.
Okay, so you're saying that although the federal government is the person who in this case is obstructing justice, it's really the bail's fault, because the bail didn't say, Your Honor, the federal government is about to essentially remove this person from the jurisdiction of the state in order to prevent that person from being tried for the crimes for which he is charged. That's now the bail's problem as opposed to the federal government's problem.
I mean, the federal government didn't do anything wrong either.
They knew that he was a detainer. They knew that they were obstructing justice.
And then as soon as he waives and everything, he waives the hearing, he waives everything, he's going to be deported as soon as they can legally take them. And they can only legally take them when he submits bail, and but for the detainer, he could walk out on the street. So I would suggest that the without fault, you have to look at the facts and circumstances as are known to the bail, the surety, when he makes the decision and brings it forward. And certainly you can look at what he did or did not do immediately after he posts the bail. It wasn't posted where it was supposed to be posted. It was supposed to have been posted in court. It was posted at the jail after working hours, and there's a time lag. There's 2 days difference between it was posted January 28th at 6 o'clock, and it's not documented in the Superior Court Clerk's office until January 30th, and the surety doesn't even come into court to make any notice about it. He came in when he wanted his money back, so he knew what to do, where to go, and I suggest in these circumstances the judge's findings
But the only
were
thing
well warranted.
the only thing the judge found was that Solomon assumed the risk, and it's in the very last sentence of the order. Is that he assumed the risks. It sounds as though shame on Solomon for posting bail after the detainer was lodged, but you knew it, he knew it, and ergo, it was a stupid act, and he's going to forfeit the bail. There's nothing complicit. There's nothing about complicity.
Well, it certainly
here.
shows that he had fault in arranging the defendant's unavailability for trial. And I think that the judge was warranted under Section 70, although the defendant didn't bring Section 70. That wasn't the statute cited in his motion. He's had a very vague motions, and I don't believe it's even...
Was the federal government's decision to deport him at the moment they did in any way influenced by the posting of bail?
Yes, that's the triggering event.
It's a condition preceding.
That's what had to happen in order for him to be deported then. Otherwise, or if there was some communication between the defendant and the court, there could have been maybe some arrangement. We could ask that, ICE not act on the detainer. There might be problems there because I don't know if that was possible, but it certainly wasn't possible given the way that the surety went about it in this case.
If ICE acts any time that someone is bailed to deport them, then isn't that going to defeat our courts of jurisdiction or potentially so over lots of cases and indicate?
Absolutely, and it's an invitation for people to basically evade prosecution and incarceration by voluntarily submitting to deportation.
So why didn't your office then move to revoke the bail once you learned that there was a detainer?
I don't know, and I don't know when our office learned that there was a detainer. I mean, I don't think that we...
But aren't you at fault?
We could get...
Isn't your office equally at fault for knowing there's a detainer and knowing that no amount of bail is going to be able to
There's nothing in the record that shows that until February 2nd or 3rd, when the defendant came in, that the Commonwealth was actually on notice that there was a detainer.
So
They're separate government
cool
entities.
hand and Luke. What we have here is a problem of communication.
I believe that there probably is a problem in communication, but... we could certainly probably find out that information, but in the normal course, it is not generally provided to us. And certainly, we're not provided with the defendant's waiver of his any rights he has not to be deported.
Why would the waiver make a difference?
Well,
Just expedite the process. If he doesn't waive, he's going to go through deportation hearings.
They may be quicker to act.
Well, it might put somebody on notice that maybe you should move to revoke the bail in this particular case, because if he comes available for ICE, things can move very quickly, and he can be out of your jurisdiction.
And you could schedule a speedy trial.
Right, we schedule, put something on the radar, or at least open up some lines of
Bail.
communication between.
Seek to increase the bail. But again, I'm asking if the federal government has changed its policy. That's what I wondered after reading these two cases, that they now are deporting people before trial.
I think had he not made bail and he was still in jail, they would have waited until after trial. So, no, I don't, but I think that if people don't know what's going on, if there isn't that communication, if someone's not alerted somehow, there's the potential where they could be deported. But a detainer is the detainer, and as long as there's an outstanding case, and he's still available for prosecution, I don't believe that they would, but,
Thank you, Ms. Sullivan.
okay, thank you.